of the Senate on Wednesday, the 11th of March 2026. Mr. Speaker, this report, the report to this petition is in the gadgets, and I would like to request members to have a look at it, because we received the report, the petition, Mr. Speaker, on the 23rd of September 2025. And once it was commissioned before the Jailer Committee, the committee, of course, undertook what it normally does, that is to conduct stakeholder engagement. Mr. Maina, or rather Honorable Maina, is a member of County Assembly of Nandi County, where my good friend from Kapsabet Boys, Senator Cherargei, comes from and represents. And this particular member of County Assembly, Mr. Speaker, is seeking in his petition several proposed amendments to the County Governments Act. To be precise, Mr. Speaker, he's seeking to amend 8 clauses, or rather 8 sections in the County Government Act, that is Section 31, Section 32, Section 33, 35, 45, 46, and 58. Mr. Speaker, the objects of his petition, once, of course, it was tabled before this committee, is, Mr. Speaker, to seek to align the functions of the county government in terms of enhancing efficiency of devolution and the principles that have been enshrined in the Constitution, particularly Article 10, 174, 175 on matters devolution and protection of county governments. Mr. Speaker, a while back, we had the statement by my learned senior, Dr. Mungatana, on an inquiry of the status of cases, particularly regarding his county government of Tana River, from the Office of the Director of Public Prosecution. What Honorable Maina, Mr. Speaker, is seeking to do in his petition is more or less what the statement by Senator Mungatana was seeking. Once we enhance and facilitate the importance of devolution and the protection of devolution by the oversight role of this House, the law governing the administration of functions at the county level is Cap 265, that is the County Governments Act. This is the one that Honorable Maina is seeking in his petition to amend. However, Mr. Speaker, upon engaging several stakeholders, among them the Office of the Attorney General, Council of Governors, Kenya Law Reform Commission, the Law Society of Kenya, among others, various memoranda was availed before the committee. And they largely spoke to an already substantial provision of almost all the aspects that he sought to amend in the County Governments Act. And their position generally, Mr. Speaker, was that we already have enough laws. We have laws having been enacted all the way from the supreme law of the land, that's the Constitution, as well as the County Governments Act. And therefore, what is missing is the governance in how we implement or enforce the provisions of law. In fact, Mr. Speaker, the committee, in its recommendation, which I'll shortly get into, rejected substantively all the proposals, but proposed only one, which in its wisdom sought to implement the provisions of the law that are being sought to be amended by Mr. or rather Honorable Maina. And Mr. Speaker, among them, to be very specific, for example, the first proposal that he wanted to make is the amendment to Section 2 of the County Governments Act. In his own desire, Honorable Maina sought to say that we need to define in law what absence of the governor or deputy governor in office means, and for what period of time does it requires a replacement. But, Mr. Speaker, you know, in the law as it is, Article 182 defines temporary absence of a governor or a deputy governor from office, and subsequently it also explains what actions are available to a county assembly or to the governor in circumstances where that particular office holder is absent in office. And that is actually the basis upon which the committee and the other stakeholders said this then is not warranted, because we have over-legislated particularly on that aspect, And number two, the Constitution provides for instances and action that needs to be done in the event of absence of such an office holder. And therefore, amending the existing law in itself will be going against the provisions of the Constitution, and therefore the committee rejected that proposal. The second proposal on the amendment to Section 30, subsection 2D, spoke about the appointment of the county executive committee members. In this case, Honorable Maina is saying that before a governor appoints an individual, he must advertise. He must seek from specific competent institutions certain individuals so that the law, according to him, would require a uniform appointment or organizational structure and process of appointing these people, subject to now the county assembly approving. Mr. Speaker, we all are aware that county executive committee members are normally political appointees, and therefore legislating on this particular aspect will take away the autonomy of a county governor who has been elected by a majority of the public from that county, so that he is controlled on how he will do it. Secondly, he is desiring to say all county governments have uniform structure. That is obviously not possible, because the county government of Nairobi, for example, has got wards more than 80, whereas the county I represent of Bomet has got only 25 wards. If therefore we were going to say we will amend the law to have a uniform structure, it means that I have got 11 county executive committee members in Bomet. Nairobi county government, which is bigger and larger, would be required by law then to have the same number of CCs. That is not possible, it is not practicable. And the committee, as well as the stakeholders that appeared before the committee, rejected that proposal again, because we have got different county governments with divergent interests, divergent views in terms of the, I would say, departments that they would create. For instance, the county government of Nairobi would have a department, for example, of disaster management or even regeneration of Nairobi River, whereas a county in Northeastern that do not have a river around does not necessarily require such kind of a department. That proposal, Mr. Speaker, equally was rejected. It was seeking to sort of have a prescriptive way of creating departments within county governments, and therefore it could not convince the committee that that was required. Mr. Speaker, the third one, which is, I'm picking a bit of those which are very critical, Section 58A, Honorable Maina is making a proposal that we create a timeline within which, where there is an existence of a vacancy in the office of the chairperson or the secretary to the County Public Service Board, that timeline is limited so that we don't have a longer and reasonably long period of time where County Public Service Board cannot sit, either to employ, to discipline, or to undertake the role of that particular office because of absence of a chairperson or absence of a secretary. In most cases, Mr. Speaker, what happens is that when a county governor, a rogue one for that matter, like the governor of Bomet, who is very rogue, if and when he does not want to run the county government appropriately, in the event of absence of an office, like in this case, we just had the County Public Service Board the other day being reconstituted. We have had almost 6 months without one. Then that law, as it is right now, has actually given the governor the leeway to decide when can he purpose to fill that position. This proposal by Honorable Maina requires that it should not be vacant for a period of more than 3 months. Actually, the proposal says that in the event of a vacancy arising in the office of the chairperson of the County Public Service Board or that of secretary, a period of 14 days should not lapse before a replacement or a process of replacement begins. That way, Mr. Speaker, it protects the operations of the County Public Service Board, protects the employees who are employed by that County Public Service Board, and ensures that rogue governors are not given the leeway to decide that there is no county public service board, and therefore there cannot be anything that can be done within that period. Secondly, Mr. Speaker, the proposal seeks to give quorum in law, that as long as there is not less than 3 members of the board is quorate for purposes of transacting the business of that particular board. That way also it cushions the county public service board from conducting its business as long as they have the number that the law provides. And Mr. Speaker, that is the proposal that the committee agreed with Honorable Minor, and therefore sought to recommend that for purposes of making sure that we cushion the county public service board and have it able to operationalize its mandate, then we should have in law quorum as well as a timeline within which, in the existence of a vacancy, we have the governor required within a period of 14 days to advertise and thereafter recruit members to the county public service board. There is another proposal that the committee, Honorable Speaker, made that requires the Council of Governors as well as the Public Service Board to create a policy or to establish a policy framework on the procedures which are generally required for purposes of making a report to this House. Remember, Mr. Speaker, under Article 96, this House is mandated by the Constitution to protect our county governments and devolution. Where there is no policy framework on how county public service boards as well as the Senate can undertake oversight of such institutions, we fail to do that the Constitution requires of us to protect the county governments, and the committee is making that proposal that we have the Council of Governors as well as the Public Service Board create a policy framework to ensure that such reports arising from the County Public Service Board can get to this House so that we have an opportunity to also interact with it and, where necessary, make additional oversight recommendations. But all in all, Mr. Speaker, Section 58A, which is a proposal to be introduced, is what the committee agreed with Honorable Minor and will make that proposal to amend the law. Mr. Speaker, as I end, I want to thank the members of the committee. I can see some in the House who participated in engaging the stakeholders, in understanding the petition, in understanding why they rejected the proposals which Honorable Minor sought to make, as well as making also far-reaching recommendations as regards the administration and management of County Public Service Board. Mr. Speaker, I thank you. I beg to move and ask my neighbor, Senator Mungatana, to second. Thank you, Mr. Speaker.
Mr. Speaker, may I start by congratulating the Honorable Sigei, who is the chair of the Legal Committee, for bringing this report before the House. I beg to second, Mr. Speaker. Mr. Speaker, Honorable Sigei is one of the most hard-working chairs, and it is